There is little else that most of us would consider the worst thing we could have to do than watching the death of a loved one. Few loved ones are exposed to the experience of viewing the death of a family member and the tragic and violent moment that this occurs. Thankfully, even fewer are subjected to the following situation. A mother being present to watch the exact moment of her son's death, replayed and repeated over 100 times in slow motion. More than this, the footage is then analysed and debated in the public domain about its actuality, as if the details of the technicalities are more important than the fact a life was so meaninglessly lost. What exactly am I talking about? Keep listening as we explore the trial proceedings and the impact that this had to all of those involved. In this, the second episode of The Death of Jack Hanley on Just Lawful.
Adelaide is the perfect place to set a horror story. You know why all those films and books are always set in sleepy conservative towns? Because sleepy conservative towns are where those things happen. Exorcism, omens, shining, poltergeists. Adelaide is Amityville or Salem, and things here go bump in the night.
Last episode we spoke about how in the early hours of December 10th, 2017, two young men would meet on a city street with its own infamy and reputation for violence, and how this would end with the most tragic of outcomes being the death of Jack Hanley. Well, this is the point where Just Lawful is going to be unlike other true crime shows. This is where I can pry into the mind of the man who was there for this entire case to understand the why as well as the what of the impacts and the effects of this case. So to do just that, it's again my privilege and my pleasure to welcome my co-host, Sean Fewster.
Daniel, what you've said there is completely correct, and everybody out there that reads my work, and I'm assuming that if you're listening to this show, you read my work, you know that I give you journalistic fact. I give you court accuracy. I give you what happened in the courtroom, but what we can do here right now is something that I've never been able to do before, and that's take you into the courtroom with me, let you know how it felt, let you know how evidence landed in the ears of the people that heard it, let you know what the emotions were going on in the courtroom, all as we dig in to the legality of this very fraught case.
Before we get into that, what sort of personal effect or perspective did this case have on you at this moment?
You're only ever going to get honesty out of me in this situation, and right now, at this point in time, as callous as it sounds, this was a court case I was covering. It was very sad.
Yep.
It was very legally complex.
Yep.
There was yet to be a deeper personal connection formed than simply covering the case, because that's the way it should be as a journalist in any realm. I often say to people, there's no such thing as an unbiased journalist.
Mm-hmm.
There's only journalists who can take their bias naturally as it occurs and put it to one side and do the job. Tell me what the story is. I'll report what the story is. I'll report what the outcome is. So right now, at this moment in chronology,
Yep.
if we're traveling back in our DeLorean, Sean's just looking at this as, this is the case I'm covering this week.
And as you said, and not that it is a callous perspective, but it's got to be that reserved, unemotional perspective at this stage. And I hate to say the fact that it is just another case of another tragedy in Adelaide that you're covering in that sense. I'm interested at this point. The reason I ask that is, as we know, as this goes on, I guess that personal investment and how that affects you certainly starts to change.
Oh, absolutely. Look, I don't think you can form a proper emotional attachment to a story unless you come at it without an emotional attachment.
Sure.
If you walk into, let's say, a road crash case, if you walk into a road crash case with a particular perspective on a make and model of car, and that make and model of car is involved in this road crash, you're compromised to begin with. You need to come in with no preconceived notions, no allegiances, no axe to grind, no row to hoe. You've just got to walk in and say, tell me what's going on.
Yeah.
And of course you form an opinion from that.
Yeah.
You're only human.
I'm going to be interested because we are going to touch on your opinion and how the effect this has on you as this unfold. I'm really looking forward to breaking this part of this case down. As we start to move within that courtroom and we unpack the how and, of course, the why of all of this. And importantly, I want to understand how this navigated and traversed that legal system, which to me is still that magical unknown realm that you talk to me about and I ask a million questions off air, you and I, when we talk about things. my endeavour here is to be listener number one, and for everyone else out there listening who may be a layman like myself and not really understand this, I want to go through some of the legal wrangling and the housekeeping of this, if we can, to get an understanding.
You're talking about the pre-trial stuff now?
I'm going to start right from the beginning of what I know about this. So please, I'm going to pose this to you. You step me through this stuff. The first thing I want to talk to you about is, look, apparently the fact that there was initially a suppression order granted on this case. What was it, the information that was suppressing, and ultimately why was the suppression then overturned?
Okay, so suppression orders tend to go down for one of three reasons. To protect the integrity of an investigation, to prevent prejudice to the eventual trial, or to prevent undue hardship to a witness, victim, or child.
Okay, so in this case, which one of those was applicable?
Number one, to protect the integrity of the investigation.
Okay.
We told you on our last episode that this was a brawl involving a bunch of kids.
Mm-hmm.
The brawl then stopped. The allegation is that the fatal punch was thrown once the brawl had stopped.
Okay.
There's a lot of people on that street corner at that time involved in this alleged brawl. It's a lot of witnesses moving around. The police need time to actually say, who did you see throw the punch? Think of the old, the movies with the lineup.
Yep.
Is it person 1 through 3, 4, 5? Who is it?
Yeah.
This is what they call an identity parade.
Okay.
Police need time to do that. So let's suppress, as the court did, the image of Reese Watherston. Because if people in the public see this in the newspaper, this is the person that's accused of killing Jack Hanley, they'll go, oh yeah, that's who I saw. Even if it doesn't 100% accord with their memory, studies have shown that they will be subconsciously influenced by someone, be it a police officer, be it a journalist, saying, here's the bloke. So as a result, the court heard from the police who said, can we have a suppression order on this kid's face just until we get the identity procedures done? We in the media don't oppose that ever.
Okay. With that stated, and I understand and I accept that, it makes sense because you're right, the human brain's a funny thing, and we can form recollections that are based on evidence given to us or facts given to us after the fact that aren't true to what we actually saw. Get that. So then why was it lifted?
It was lifted because the police finished their procedures.
Okay.
So sometimes these orders stay down for a couple of weeks. Sometimes it's only for a couple of days. But magistrates are very good in South Australia with this particular type of suppression order. They'll always set a limit on it. They'll say, the trial is X number of months away.
Yep.
You have until this date to finish your identity procedures. On that date, come back before me. If you've not finished, I'm going to want a really good excuse as to why.
Okay.
Otherwise, I'm going to lift that suppression order.
And this is, as you said before, this happens pre-trials. This is before any of that happens.
This is before even an accused enters a plea, guilty or not guilty. This is one of the earliest mechanisms in what they call the committal process, which is just the pre-trial process. Suppression
orders are, I find, fascinating, and I know that, as you said, this is one that's used in this sense, and I know there's a number of them used for a number of different... We're going to talk and unpack suppression orders at a later date. I guarantee we're coming back to this, and there's going to be something procedurally we are going to unpack suppression orders at some point, because I know there is so much involved in those.
For anyone who's a Man of La Mancha fan, this is my personal windmill at which I charge as suppression orders.
Absolutely. So I know there's plenty in that, and we're going to unpack them at some point. But in the interest of this case, we're going to move on, because as you said, this is pre-trial, before we even get there. So the next point I want to raise is this, and the aspect here for me is interesting, because... my perspective is that when most of us think of a courtroom trial, we generally have a judge and a defense and a jury and a prosecution, and it's all pretty standard, right? We've all seen a million court cases on a million different crime shows or movies and that's how it's always predicted and shown to us, I should say. My understanding here is that that's not always the case of what we see, and in fact, in this instance, we had what's known as this thing called a trial by judge alone. Okay, Sean, tell me, why was this a trial by judge alone situation? And I guess, as an extension, what does it mean? And why would this be something that's requested or advantageous? And who would benefit from this?
In South Australia, you have a choice as a defendant. You can stand trial in front of a jury of 12 of your peers who will be randomly selected from the public in order to officiate and adjudicate upon your matter.
Okay.
Standard, the way it works everywhere.
That's
Western justice.
Yep.
Or you can elect for a trial by judge alone, where you say, I'll forego my right to a jury. I simply want the judge, instead of running the court case, to actually listen to all of the evidence and the judge to be the one to come back with the decision of guilty or not guilty.
Okay.
So it's a choice. It's a choice you have to make after you enter your guilty plea and before your trial... your not guilty plea and before your trial starts.
Okay. All right, I'm not sure I was aware that I had the choice as a defendant to opt for one or the other.
You do, and your lawyer will advise you of
Okay.
this.
Well, clearly I haven't had to be in that situation, which I think is a good thing at this stage. But I clearly wasn't aware I had that optional choice. Tell me, why would I opt for one over the other? Why would I say I don't want 12 men tried and true to judge me, as opposed to that one singular judge to adjudicate this for me?
My experience, it tends to happen in two particular types of cases.
Mm-hmm.
If you have a really legally complex question that needs to be answered,
Okay.
or if you have an incredibly emotive set of allegations. So let's break those down.
Yeah.
Legally complex case. 12 ordinary people from the community may or may not be versed in the ins and outs of racial vilification laws.
Mm-hmm.
They might not be versed on the ins and outs of child sex abuse laws. They might not be versed on the ins and outs of motor mechanics and how a vehicle's specs dictate whether or not it or the driver is responsible for a crash.
Sure.
If you, as a defendant or as a lawyer, very well, heeled lawyer, looks at the evidence and says, this is going to be really tricky. We could be here for a while if a jury has to decide this. Or, I just don't trust that a jury is going to understand this. You can opt for a trial by judge alone, because a judge has to become aware of all that information, has to listen to it all in a very deep way and bring their years of experience to the matter.
Well, that makes it sound like, why wouldn't everyone opt for that, Sean? Like, why wouldn't everyone say, forgo the jury, I just want to speak to one person and have that judge have to be engaged in me in that level? Why would I choose otherwise?
Anecdotally,
Yeah.
if you lose and you're found guilty, trials that have been conducted by a judge alone tend to attract greater penalties than trials that were conducted in front of a jury.
I'm going to focus on the point you mentioned there of anecdotally. I feel like that was a very deliberate choice of
Very
wording.
deliberate choice of words.
Sure, and because I can imagine that that every offence has a penalty to it. So we're going to put our finger on the word, anecdotally there,
based on my experience,
sure,
which is what this show's all about.
Absolutely correct.
So that's one reason.
Okay.
Is the legally complex. The second is what we'll call the emotionally fraught. And we're going to get grotty here for a minute, folks. So this is your trigger warning. Strap in. If we're talking about rape,
yep,
if we're talking about sexual assault,
mm-hmm,
these are highly charged alleged offences.
Mm.
You as a defendant or you as a lawyer may look at the jury situation and say, I really don't want my client who's accused of committing this kind of sex crime to sit on a jury where I could potentially have 7 or 8 women hearing this.
Yeah.
Or I might potentially have 9 fathers. I really just want a judge who is duty bound to come to this with no bias whatsoever. Because that's the thing. At law, a judge cannot be biased.
Sure.
So you may say, I am really, really looking at a bad situation here. And jury's going to hang me just the moment they hear this.
Yeah.
I'm done on toast. I'll go for a judge alone because at least then I'll get a fair hearing. I risk a worse penalty if I'm found guilty, anecdotally, but it's a better toss of the coin than trusting myself to, 4 members of the Mums Association of Adelaide, 5 guys who are, scout leaders, and, 3 church people.
That's kind of, I guess, a little bit of that housekeeping. I guess that kind of sets the scene for how we went about this. So we know that suppression orders put on for the right reasons, removed appropriately. We're now moving into this concept here of an idea of what they call, trial by judge alone.
Absolutely. This now moved into the hands of Justice Anne Bampton of the Supreme Court, and it would be up to her to hear all of the evidence and come back with the verdict.
As we discussed, Sean, we've now moved into the actual court case, and this is going to be presided, as you said, by Justice Anne Bampton. In my opinion, and purely from my own research, a large portion, if not the entire outcome of this case, simplistically hinges on almost singularly the following 2 perspectives of this case. For me, the first perspective is when prosecutor Mark Normancy states that the accused hit him as hard as he possibly could. The prosecution alleges the punch was an unlawful and dangerous act. The second perspective is where Watherston and his defence team state that he was acting in self-defence, and Watherston even stated while giving evidence under oath, I am not a fighter, I do not like to be in that situation, I was scared for my own safety, I never wanted to fight. Right there are 2 very differing perspectives on what's occurred here. So Sean, I need you to weigh in for me at this point. I wasn't there, I didn't see the whole case. Am I being too simplistic, or what else do I need to know, or what else do I need to consider here?
You're 66% right.
2/3.
2/3. You have 2/3 of this.
Okay.
Absolutely, yes. The strike being with all possible force is
Okay.
one of the central factors in this case. The other is Watherston's claim, I feared for my life. Absolutely.
So they're the two I got.
They're the two you got.
What
There's
did I
a
miss?
third.
What have I missed?
Whether or not Jack Hanley took any aggressive action.
Okay, so elaborate for me. Explain. Help me out here. So how does that play into this?
Think of it like mechanisms. All possible force is the mechanism of the act. What happened to cause a death?
Okay.
Watherston fearing for his life is a rebuttal. I didn't do anything wrong because I had this reasoning. But to get to that reasoning, to get to the idea that Watherston had a reason to fear for his life, which caused him to throw that punch, the mechanism that you're missing in the middle is, what did or didn't Jack do? Was he doing anything that was deserving, very big air quotes around that,
Sure.
of the punch? And in doing so, has that conduct thereby mitigated what Watherston has done? Did Jack do anything that made Reese react? So that's the third piece.
There's a piece I'm missing there is what did or didn't Jack do in that sense that may or may not have provoked Reese to take that, in his mind, defensive action.
That's right. And keep in mind, we're going to need to talk about what Jack may or may not have done without talking about what kind of person Jack was. The prosecution and the defense, they're not going to get into Jack's character, Jack's attitude. They're only going to look at Jack's actions.
Why is that?
Because he's no longer here to talk about his own personality and beliefs. Nobody else is allowed to do that because that would be hearsay. They can only talk about what they witnessed with their own two eyes or heard with their own two ears. And so we can only talk about Jack in the context of the trial process as an action.
Wow. Okay. Look, that's a perspective, and I think a standpoint that I personally wouldn't have probably appreciated until you put it at that point. I wouldn't have even had the idea to conceive that, I guess. So I can only imagine there's a lot of people out there right now going, but how can we not talk about who this person was or what they may or may not have, how this person would normally behave? How can we remove all of that and just simply talk about this action? There's 3 points we need to consider here, not just the two perspectives. I talked about 3 points. So you talked about all possible force.
Yep.
I think one you talked about, we talked about before, was one of no aggressive action, and the third one being Watherston fearing for his life.
That's right.
So those are the 3 points from you in your mind that really are key to this and crucial.
It's what rises and falls.
Let's unpack these 3 points you talk about. Let's see, break them down, understand how crucial they are. The first one I want to talk about here, you mentioned all possible force. What do you mean by all possible force?
So Prosecutor Mark Norman starts the trial by giving an opening address to the judge. The judge, of course, sitting in the place of the jury. And he tells the court that Jack Hanley was actively trying to get away from a Hindley Street brawl when he was killed by a single extremely powerful punch that was neither necessary nor appropriate. So right there, what he's doing is he's using language to set up the elements of an offence.
Okay.
Because the charge is manslaughter, not murder, manslaughter.
See, right there, I'm not sure that a lot of people realise that either.
Okay, so let's talk about that. Manslaughter is an unlawful and dangerous act that causes death, or a reckless act committed with disregard that leads to death. No other offence has the range of manslaughter.
Yeah, right.
You hear it described as everything from prank to just shy of murder. So, breaking down what Mark Norman says there, a single extremely powerful punch, because it was neither necessary nor appropriate in the prosecution case, this is manslaughter. It's an unlawful act. There's no need to throw it. There's no legal reason to throw that punch.
Right.
So it's not just pretty words.
No.
It's not just emotional verbiage.
Yeah.
It's actually doing a lot of heavy lifting.
Yeah.
He says that Jack Hanley tried to jump out of the way of Reese Watherston only to be aggressively pursued and killed. He's painting you a picture here. He's saying this isn't just biff. This is chase after, throw the punch.
Yeah, right.
And he's saying that Mr. Hanley's feet were off the floor. He was actually physically jumping away, trying to avoid what happened. He was not willingly or willfully engaging in combat. He was offering no threat or danger. Watherston aggressively pursued him and hit him as hard as he possibly could. It was an extremely powerful punch, neither necessary nor proportionate, and then Wotherston immediately turned and walked away.
Pretty powerful and evocative sort of language, as you said. And it sets up that concept that it wasn't necessary, didn't need to happen. Jack wasn't necessarily doing anything to cause or bring that upon himself. Wotherston then acted. Clearly, if he's chased him, has had momentary time to reconsider that action, still went ahead with it. I want to talk to you, so all possible force. So that's what Prosecutor Norman has said at that point. Wonderful words to be set up in that sense. However, what do we then use? How can we actually start to put some meaning or some validity to that?
So obviously, as we said earlier, lots of eyewitnesses,
Sure.
including the kids who were involved in the earlier brawl.
Mm-hmm.
As we'll develop, there's a fair bit of intoxication going on there.
Yeah.
Some MDMA, some nozzies, some alcohol.
Absolutely.
May not have had the clearest recollection.
Absolutely.
Prosecution had a couple of independent witnesses, though, including, of all things, a radio announcer by the name of Robert McCasker, on his way to work the early hours of the morning in his car.
Yeah.
And he said, I saw it happen. I saw a man backing away, jumping away, protecting himself. When he was punched, his head hit flush on the ground. I believe he was knocked out even before he hit the ground. The punch looked like it was thrown with all force possible, like Wotherston's whole weight was behind it,
Right.
with force. And then he said, I heard a sickening thud when Jack's head hit the ground. He's in his car, driving past, busy Hanley Street, busy intersection, other cars, horns, and he says, I heard a sickening thud when his head hit the ground. Imagine the volume of that impact to make it over all that ambient noise.
Yeah, you're right. We're not talking about a deadly quiet street where you could hear a pin drop. We're talking about a busy intersection at that point, especially that time the clubs have just let out. It's 5 o'clock in the morning. There is movement, there is noise, there is traffic, as you mentioned. To hear that, it had to be a heck of a thud.
And he wasn't the only one to hear it. In the intersection, waiting to turn right from Morfett Street to go further down Hanley Street to go to McDonald's, of all places, there was actually another car being driven by Andrew Miller. Andrew and his then partner were on their way home, decided to stop and grab some Maccas for the drive. They had their dash cam running, and their dash cam caught the fatal blow.
So this is the video footage we talk about. We have video footage now of this incident.
And the crucial nature of this video can't be overstated because Hanley Street's covered in cameras, right?
Yeah.
All over the place. Would you believe that not a single Hanley Street CCTV camera caught the incident itself? The lead up, the follow up, none of them caught the incident. They just all happened to be turned away from that section of street at exactly the wrong time. So the only piece of video footage that exists, imagine that, is a dash cam sitting in the middle of Morfett Street waiting to turn right.
Yeah.
You can hear Andrew and his then girlfriend talking over the top of this saying, oh my gosh, what's happening over there? Oh, look at that. Oh, it's really painful to hear. Andrew's ex-girlfriend described the sound of Jack's head striking the pavement as a horrible loud thud that sounded like it happened right next to me, even though we were across the road.
So they're across the road in their car waiting to turn right, and they could still hear the thud of his head hitting the concrete.
That's right.
Okay. I need to ask you about this, Sean, because at the top of the episode, I made the point of someone having to witness a loved one die, let alone seeing it 100 times over, and then while being scrutinised in front of a court of law. I want you to talk to me here about the reaction of Jack's mother, Julie, and her experience having to endure this.
So this trial was held in one of the larger courtrooms in South Australia. We have two big courtrooms. There's a row at the front for the journalists, and then there's 3 or 4 rows behind them. Julie Kelbin, Jack's mother, sat on the left-hand side of the court, level with the prosecutor, directly behind me.
Yeah.
That's how I got to know her, because she was the friendly face behind me who would say hello every time she walked in. Oh, are you one of the journalists? Oh, my name's Julie. Jack's my son. Hello, Julie. Lovely to meet you. Very sorry for your loss. Not much more than that. Came to the point where the video from Andrew's dash cam was played in court. And as you can imagine, like I said, this is crucial evidence. So it doesn't get played once. It gets played several times. And it gets played at full speed It gets played at half speed. It gets played frame by frame. It gets played slow motion. It gets paused on the moment that the punch connects. It gets paused instants before Jack's head hits the concrete. It then gets rewound all over again. And it has to be played for multiple witnesses. You know, is this your dash cam footage? Is this your ex-boyfriend's dash cam footage? You're an eyewitness. Does this accord with your memory? You know, Mr. McCasker, you said that you heard it. Was it at this point? No. Click forward a frame. Was it at this point? No. Click forward a frame. I don't really have the words for what it was like. I could feel Julie behind me. She was doing an incredible job of keeping her composure, but that wasn't stopping the tears. And I could feel the seats shaking because she was shaking with renewed shock, with trauma, with grief. Because the prosecution knew that this was happening, and they were not unkind about it. They had a job to do. They had to prove this. And Julie, God love her, she wasn't going to leave because she didn't want to make a scene. She knew this had to be done. She'd been warned, and she steeled herself for it, and she sat through it. I've seen other members of families of victims get up and leave court when certain pieces of evidence are on. I've seen near riots in courtrooms. I remember a murder case I covered once where the family hadn't been briefed about how their loved ones had died and found out in the court.
Wow.
And that was a near riot.
Yeah.
Julie's composure and perseverance was incredible, but it was killing her. Just every now and again you would hear a sob escape, or kind of like a grief squeak, you know, when you're trying to hold it in and it just squeaks out. It was something I'll never, ever forget. And, you know, by the end of a morning of evidence, Julie would be either bright red from holding it in or grey. It was something unlike I've ever seen before.
I can't honestly imagine that, Sean. As I said, that most people are spared, I guess, the horror of watching a loved one pass. To have it replayed over and over, knowing there's a reason why that needs to be done. And as you said, she steeled herself to do that. I can only imagine, the courage it took to do that, and B, the fortitude to stay through that process. Just before we move on to this next point, I need to ask you, Sean, what about the effect on yourself being in that courtroom and watching this unfold? What did that do to you having to watch this? Because I
knew you were going to ask this.
Well, I asked you earlier what emotional attachment you had to this. Why, at this point, this has to start changing. Something has to be coming here.
It's traumatizing. You know, I've had the misfortune of seeing people die in my work and in my personal life. But you see it once.
Yeah.
You don't see it again and again. I mean, this was a snuff film.
Yeah.
That's exactly what it was.
Sure.
It was a completely legal, necessary, evidentiary, appropriate snuff film.
Yep.
And I lost count of how many times I watched Jack Hanley die that day.
Yeah.
I'm watching it play out behind my eyes right now while we're talking about this. Like, I can actually, if I close my eyes, I can see the footage. It will never leave me. And it was traumatizing. I always say it's not about my pain. It's about the victim's pain. I've got to put my pain aside in order to report the story. And that's what I do. But I'll tell you, I went home that night and I just sort of sat with it and let it all flow out of me again, because I sometimes fear that one day I'm going to get dementia and all I'm going to remember are court cases. If that's the case, I have a bad feeling that this piece of footage is something that will play endlessly on loop in my head, because that's burned in there now.
Yeah.
That was also the first time that I approached Julie beyond a hello.
Yeah.
Because when I came out of court at one point in the sort of waiting area, her family she'd told them all she was okay, she was fine, I'll be okay, and her family had gone to get some coffees, get some sandwiches, get some drinks. And she'd just broken down. So I just walked over to her as a human being and just said, "I'm so sorry, can I do anything for you?" And she actually stood up and she hugged me. Complete stranger at that point.
Yeah.
You know, it's a journalist. She knew that much. Gave me a hug and just said, "Thank you so much for asking." And I just made a point of it after that every day to say hello to her, check on her, see how she was feeling. Because you said it yourself, nobody should have to watch that. I shouldn't have had to watch
No.
that. And Julie damn well shouldn't have had to watch that.
Look, Sean, you've discussed there. We've now seen the video footage, as you mentioned, and that sort of shows us the moment of this tragic incident. You mentioned that all the other cameras on High Street, etc., were faced away, for example, and didn't capture this. So we don't have the after, we don't have the before. So this is the part where we need to discuss, well, how do we know what that lead up was, and how can we put some validity to the stories or the concerns or the evidence given here? And I guess for that, this is where we look at the evidence given from those witnesses. Is that correct?
That's right. The eyewitnesses come into play here.
Okay. So I want to start here. I'm going to read a couple of lines here from, we spoke about in the last episode, Mitchell Blackie, which, as we know, was one of Jack's friends who was defending the honour of a young lady he was with at the time. And that seems to be what kicked off the initial fight that apparently fizzled out. So I just want to read a couple of lines from Mitchell here. I hit one of them with the trolley. A fight broke out. The fight had finished when I saw Jack get punched. I saw him get punched in front of me. He was doing nothing, just trying to avoid it. The punch was loud, hard, awful. Jack just fell backwards on the ground. Someone said, "Look at your fat friend asleep. That's what you get." I'm going to be honest there, I had to omit a word that's written here that I'm not going to say on air. That's the evidence given by Mitchell Blackie. And I'm going to put it up front. There's a lot of intoxication from a lot of people on a lot of different substances that night. If this evidence is to be believed, that's pretty damning.
And the prosecution had a corroborating witness. Better yet, they had a sober, non-involved corroborating witness.
See, this is important. You mentioned earlier we had two other people that were third parties not involved in this and not under the influence. So this is a third non-connected, non-under the influence witness.
That's right. Because those earlier two witnesses saw the punch.
Sure.
In one case, one recorded it.
Yes.
This witness saw the aftermath to the punch.
Okay.
His name was Christopher Jones, and he says that Jack fell like a tree cut at the base, quite stiff, and Reese began taunting him, yelling at him, saying, "You're not able to take a hit. You're a bitch." He made those comments as Jack was convulsing on the ground. He didn't appear at all concerned. He kept calling him a little bitch shaking on the ground who can't take a hit. And then he left the scene.
This witness, Christopher Jones, you talked about here. My understanding is the defence did take some objection to this.
They did.
They wanted to pick at this statement and evidence given by him. My understanding is that they were concerned that it wasn't. He couldn't convincingly or concretely say that it was actually Reese that had made those derogatory comments. Is that?
That's right. That was the effect of their defence questioning.
And to that point, I've got a statement here from Christopher as well, where he said, look, it was definitely someone within the direct vicinity of the deceased. To say it could have been another person in the area, I can't rule it out. When you and I talk, just as we do about things, we've talked about this case before and about this situation, and when we've talked about this, you're always very deliberate in stating, this is why it's so important to highlight that part of the statement, I can't rule it out. Why is it so important that that's highlighted?
Because the standard at a trial is that the prosecution must prove a case beyond reasonable doubt. So if something can't be ruled out by a witness, well, then it's possible it happened the other way. If it's possible it happened the other way, maybe you've got that magical concept of reasonable doubt.
Reasonable doubt. We hear this idea of beyond reasonable doubt. Talk to me a little bit about how easy or hard is it to, create reasonable doubt?
So it's actually very simple, because the definition of reasonable is what an ordinary person would think. So if I can convince you that maybe, just maybe, my shoes are blue today rather than red, and you say, well, Sean always wears red shoes, but I know that he went to the shops. Maybe he did buy some blue shoes. Look, I can't rule out that maybe he's wearing blue shoes today. I therefore have reasonable doubt. Now apply that to something far more serious than my footwear. Let's take this case as an example. Do you know for a fact that Reese Watherston threw that punch with all possible force after the fight finished, taunted Jack, and then left the scene? Well, I can't say for certain, says the witness, that it was definitely Reese that did the taunting. Oh. well, if there's doubt that Reese did the taunting, and that's part of the prosecution case, is it reasonable to think that maybe they might be mistaken about other pieces as well? Think of it like pulling on a thread, undoing a tapestry. Or, remember that old game Kerplunk with the straws? Pull enough straws out and the marble drops?
Definitely.
Same thing. Can you dig enough holes in this so that you go, well, I can't really be satisfied with all of your case? And that's the thing. As a juror, or in this case a judge, you have to be satisfied beyond reasonable doubt. Any doubt, shouldn't be saying a verdict.
And you just touched on a really interesting point there, because right now we're not trying to convince 12 individual people of one thing or another. We are simply dealing, as we said before, a judge, trial by judge alone situation. We are convincing and presenting this information to one singular person.
One singular, incredibly legally educated person.
Yes.
And now we see why this complex, emotional case is a judge alone case.
Yeah, absolutely. And when you start talking, I tried really hard not to use this, and I know your good friend Pembo is going to be lovely when I say this, the legalese of this piece.
Yeah.
When we talk about the definitions and the concepts and the understanding of the legal vernacular for this, we are talking about very specific, very defined and deliberate terminology. So to have a complex case with such strict understanding of those letters of the law by someone there for that exact reason, to have such an elevated knowledge of this situation, now we sort of understand.
It's why I always say we don't have a justice system. We have a legal system.
Yeah.
Because that's what we're doing. In this case in particular, we are preaching to the converted.
Yeah.
As prosecution and defense. We're not asking ordinary people to decide this. We're asking the experts to agree.
As you said, highly emotive and or complex, and we take it out of the hands of those like myself and possibly yourself who, well, less you, I'm going to say more me in this case, that are not familiar with this environment, this landscape, this world, if you like. It's a very complex situation, and as you said, it highlights why it's been done in this deliberate thing. So I asked the question earlier, who would this be advantageous to? Why would we do that? I think we're starting to understand why the defence would have gone for this situation. Sean, we're going to move into the third point that you raised earlier, and that was the concept that Watherston feared for his life. There was something happening that made him fearful and therefore evoked that reaction. And that, I guess, is the whole concept of his claim of self-defense. We talked earlier, and we talked about this very crucial video footage for this case. The truth is there's a second piece of video footage here that we haven't discussed yet, and I want to bring that to the attention of our listeners here. There is footage directly after this incident of Reese Watherston entering a taxi cab, and it's the taxi footage from inside the cab. Reese enters the cab, and he's heard to say, "I had to put a guy down tonight."
Yeah, and the taxi driver's response is along the lines of, "Oh, I just heard over the radio that somebody died." And Reese's reaction was, "Sorry, what?"
So this is the second piece of video footage, which clearly doesn't have the visual impact, if you like, of the other footage. It's just as crucial, surely, in the determination of this case, you would think.
Absolutely, because it goes to demeanour. Again, prosecution's trying to prove their case beyond a reasonable doubt. If the doubt is going to be raised that, well, maybe Jack did something to bring this on himself, pieces of evidence like that are crucial to saying, this was Reese's mindset at the time. Leave it up to the judge to decide, is he full of bluster at this moment? Is he full of ego? Is he full of fear? Is he upset when he says, I had to put a guy down? Is he braggadocious? That's the sort of thing that a judge needs to watch again and again and again to make up their own mind. What do I think that piece of footage is telling me?
That is a really good point, that demeanour and that judgment from Justice Hampton at this point. Because I could quite conceivably make the argument here, and I'm being completely impartial to this, just objectively looking at that and going, that doesn't necessarily tell me whether Jack did or didn't approach Reese and attack him first. It could, if we want to make that suggestion, make Reese sound incredibly braggadocious and very much, the aggressor here. We don't know. Is he just in a heightened state? Is the adrenaline pumping? Has this situation just happened? Whether he's defended himself or not, he's gone, oh my God, gets in there, whew, okay, yeah, I just had to put a guy down. We could make that case either way, and I guess what I've just done there is muddied the waters, if you like, and therefore just increased the concept of that reasonable doubt.
That's right.
There's one other point I want to bring up here, which, again, Partway through this trial proceeding, around about this time, Reese's appearance changes. He suddenly appears in court with his head completely shaved bald, a very different look to how he's been up this entire time, and certainly on the evening. Now, that may mean nothing at all, but Sean, you and I have just talked before. Talk to me about that. Why do you think this might have happened? What do you think might have been a part of this?
Look, I'm not one to speculate. I've made a career out of not speculating, but I will remind you and the listeners that we talked at the very start of this case about how important it was that Reese's visual identity wasn't seen, while eyewitnesses determined absolutely who was who in that incident.
Treading very carefully here, I suppose, if we want to, we could possibly look at very tenuous threads of maybe if he doesn't look like he did on that video footage, are we looking at the same person, or is there reasonable doubt in who I think that person may be?
There was a lot of talk, for example, to take that point and extrapolate further, over the colour of different t-shirts being worn by different people in the video and who was in what colour. It all goes into reasonable doubt. Yeah. How sure are you that you've seen what you've just seen?
Yeah, it sounds like the more feet we get in that pond and start kicking around at the silt at the bottom, the muddier the water gets, and therefore, how do we see clearly?
Well, Reese Watherston really wanted the court to see clearly, and he wanted the court to see clearly his way. He took the stand and he said, I was staying out of it. I didn't want to fight. And he's talking about the incident involving Mitchell Blackie, the young girl, the piece of trolley, the inciting incident, as we've been calling it. So he says, I stood on the sidelines. I was worried for my friends. They were little guys compared to the other group. He said that he was actually sent sprawling onto the roadway as the push and the shove happened, and after picking himself back up and moving back onto the footpath, Mr. Hanley, he says, Jack, attacked him. He said, a huge male approached me with clenched fists swinging. I tried to dodge them and started swinging back. He was huge compared to me. I saw a fist go past my face, and then I was dodging them and swinging back. They were big throws. He's a big guy. I'm not a fighter. I don't like to be in that situation. I was scared for my own safety. I never wanted to fight. I only punched him once to get him off me and to protect myself. I don't even remember seeing him fall. I just walked away. I wanted to get the hell out of there. The spotlight had sort of just drawn to me.
Now, when I hear that, my first reaction is that is very much in stark contrast to basically every other piece of evidence tendered that we've heard so far.
It is the complete contrary. It's not just stark contrast. It is the opposite. It's, I was not involved. I was on the sidelines. He came at me.
Okay.
Every other bit of evidence we've heard to this point is Jack was on the sidelines. Reese went after him.
Now, that is the point I want to get to here. Every other piece of evidence we've heard, so every other piece of evidence that you and I have proposed and put forward to our listeners is very different to that. When we're talking about being in that courtroom, which only you were, between you and myself and the listeners, we weren't. Is that how it played out in the court, or have you and I just selectively chosen those pieces of evidence? Because was the evidence tendered in court as stark in contrast as what we've just described?
Absolutely. And there was more of it. We don't have the time to go through an entire multi-day, multi-week trial on this show. We wish we did. But every piece of evidence that we have presented so far is exactly how it was said in court and what was said in court. Mm-hmm. And the weight of the evidence in the prosecution case was all about Jack running away and getting struck, having done nothing beforehand. This is the complete 180 from that.
Yeah. And that's so essentially Reese's own evidence is the only evidence pointing to that version of this case.
That's right.
Okay.
That's right.
My understanding is prosecution was less than impressed by this.
Look, Prosecutor Mark Norman SC, I consider him to be a friend, as much as anybody can be friendly with someone who is in a workplace, sometimes adversarial situation. Yep. He is a great guy, incredibly eloquent, beautiful British accent, very calm. It's like listening to Doctor Who in court, Never raises his voice, never gets angry until this cross-examination. It's the first time I'd ever seen Mark Norman get angry with somebody, and he was very angry because he stood up when Reese Watherston finished his evidence, when he took his turn to cross-examine, and he said, "You're exaggerating to justify what you did. Jack Hanley was only 9 centimetres taller than you. He was 22, you were 20. You're exaggerating when you say he was huge. You say he attacked you and you'd been doing nothing but yelling. I suggest that's a lie. You don't often hear that word in court. You don't hear someone bold-faced say, you're lying.
Yeah.
I suggest to you the evidence is different. I suggest to you that that doesn't accord with the facts. Now, Mark Norman went straight for the throat. I suggest to you that's a lie. That is the politest way of saying you are making everything up.
And that's what, when you and I have talked about this, that's kind of the implication you've given to me, that you believe Mark Norman felt that this evidence by Reese was grossly exaggerated in his favour.
Absolutely. And Reese stood his ground. He said, I'm not exaggerating. Jack was a very big male overall. He was standing right in front of me swinging. I could see his size. I did know, he said, that mine had to be a solid punch just because of the size of him. Think about that evidence for a minute. Everyone to this point has said that the punch was thrown with all possible force. Reese doesn't disagree, but he says he was justified in doing so. Go back to the prosecution opening. Mark Norman, it was unnecessary and inappropriate. Reese is like, no, I hit him as hard as I could because I had to. That's his position, and he's not moving away from it. He's saying that apart from that, I was never angry, violent, or aggressive. And Mark Norman said, well, you could have backed away. Oh no, it all happened very quickly. And we were throwing an equal number of punches at each other. Because he says, I'm not the aggressor. I'm not an aggressive person. Mark Norman's response to that was quite pointed. Jack was physically hopping to get away from you, he said. He had his back to you. He had his arm up to keep you away from him. You threw a punch at him even though his back was turned. It didn't even matter to you that he was trying to get away. Your punch was so hard that we could see on that video that your feet came off the floor. You gave it everything you had. He said, you're either lying or you've convinced yourself that that footage shows something other than you being the aggressor and that you didn't hit him as hard as you could. And this is the key point here for me. Mark Norman said, it was more important to you to win that fight than it was to walk away. You used all your strength as a football player and as a bricklayer to launch the most vicious punch you could. Now that's damning. It's absolutely damning accusation. Reese looked him dead in the eye and said, I am not a liar.
And with that denial from Reese Watherston, this is where we will pick back up for the verdict of this case next week. Sean, what can we expect to talk about when we do pick this back up next week?
We're going to talk about the verdict. We're going to talk about why Justice Ann Bampton decided as she did.
Mm-hmm.
We're going to talk about the fallout of that case for Reese Watherston, for Julie Kelbin, for their families. And we're going to talk about what the DPP decided to do in the wake of the verdict.
There you go. I can't wait. There's some big things still to come. You thought just getting to the end of the court case was going to be the crux of this story. It's been a horrible tragedy. You've heard some of the concept of how we run through this thing that, as Sean said, we call a legal system, not a justice system. And I think you're starting to understand why and what the premise of this show is all about, that just versus lawful concept. But this is where we're going to pick back up next week. In the meantime, just want to again thank everyone who's tuned in to listen to us. If you listened to us last week, thank you so much for rejoining us. If this was your first episode listening to us, thank you so much. Hopefully someone's put you onto us. We appreciate everyone that has reached out to us and has listened to the show. We also want to say thank you to the 5AA team. If you liked what you heard, please let them know as well. But you can also catch us and let us know your thoughts and ideas and feedback to us at Just Lawful Podcast on Facebook and Instagram. You can also get a hold of us at Just Lawful Pod on Twitter. And again, as I said last week, if you want to keep up to the latest in Adelaide and true crime via Sean's work with The Advertiser, and I think, if I'm not wrong, possibly even back on some of those more social network avenues these days, please check him out at Sean Fewster on both Facebook and Twitter. And with that, again, a massive thank you to everyone who listened to us, and we look forward to speaking to you again next week.